Welcome, law students, to an explainer that transforms constitutional history into an absolute high-stakes legal drama. Today, we're unpacking a massive tug-of-war over who truly controls the ultimate law of the land. It's Parliament versus the Judiciary. On one side, you've got Parliament, armed with the power to amend laws and represent the majority. And on the other, the Judiciary, stepping up as the ultimate guardian of the Constitution. It's a classic standoff, and honestly, the stakes could not be higher. So, let's kick things off with a huge question, one that literally goes to the very heart of constitutional law. If Parliament has the power to amend the Supreme Rulebook, is there anything actually stopping them from completely rewriting it? Like, could a parliamentary majority just theoretically erase the entire foundation of the Republic? Keep that in the back of your mind, because the answer to that has shifted dramatically over the decades, and understanding that exact shift is absolutely crucial for your exams. To figure that out, we're going to walk chronologically through these major battles. We'll hit amending the Supreme Rulebook, the First Amendment impact, the Golak-Nath verdict, the 42nd Amendment overhaul, and finally wrap it up with a basic structured doctrine. Okay, Section 1, amending the Supreme Rulebook. Let's establish the absolute baseline rules of the game. The entire foundation of this conflict really rests on Article 368. This is what gives Parliament, and strictly only Parliament, the explicit power to amend the Constitution, assuming they follow due procedure, of course. It's the legislative engine driving all constitutional change. The framers intentionally built it this way so the law could adapt to a rapidly changing society. But here's the thing, it's not just a magic wand they can wave whenever they want. The Constitution itself lays out exactly how this power can be used, and it totally depends on which specific part of the rulebook they're trying to tweak. So the amendment process actually breaks down into 3 distinct paths. For simpler administrative stuff, like admitting new states, changing the quorum in Parliament, or adjusting official languages, you just need a simple majority. Easy enough, right? But if Parliament wants to touch the really heavy stuff, like fundamental rights or directive principles, a special majority is strictly mandated. And finally, if you're trying to alter the federal structure itself, that requires a special majority plus the consent of at least half of the state legislatures. That built-in rigidity was basically designed to act as a safeguard for the nation's core framework. Moving on to Section 2, the First Amendment impact. Because, well, the ink was barely even dry in 1950 before Parliament decided it was time for some major changes. Right out of the gate in 1951, Parliament made a massive move with the First Amendment. They were pushing hard for policy necessities like land reform and zamindari abolition, and to do that, they realized they needed to shield certain laws from the courts. So they created the Ninth Schedule. Think about how wild that is. They essentially built a constitutional vault. By dropping land reform laws into this newly minted Ninth Schedule, the intent was to make them completely untouchable by judicial review. Plus, they added what they called reasonable and justiciable restrictions on the freedom of speech for things like public order. Parliament was clearly flexing its Article 368 muscles early on to push through its social and economic agenda. Which brings us to Section 3, the Golak-Nath verdict. Because, the Judiciary certainly wasn't going to just sit back forever. And that leads to a huge plot twist in 1967. Here is your crucial exam summary for the Golak-Nath case. In 1967, the Supreme Court threw up a massive judicial roadblock. They outright stripped Parliament of the power to touch fundamental rights whatsoever. The court actually reversed its own earlier decisions by a super narrow majority and declared that the rights guaranteed in Part 3 of the Constitution were completely sacrosanct, basically untouchable. Even if Parliament argued it was absolutely necessary to amend those rights to implement directive principles, the court just said nope. They elevated fundamental rights to this transcendental position, completely beyond the reach of any parliamentary majority. Well, as you can probably guess, Parliament immediately retaliated. Enter the 24th Amendment Act in 1971. They forcefully affirmed that Article 368 gave them the right to amend literally any part of the Constitution. Yes, including those sacred fundamental rights. And actually, they went a step further. Just to make sure their amendments couldn't get blocked at the executive level, they made it absolutely compulsory for the president to give his assent to a constitutional amendment bill. It was a direct, heavy-hitting constitutional counterpunch to the Golak-Nath verdict, perfectly setting the stage for an even bigger showdown. Section 4, the 42nd Amendment overhaul. This whole tug-of-war finally reached its absolute peak during the emergency era. You just have to look at the sheer, staggering scale of the 42nd Amendment in 1976. Parliament went all in, trying to consolidate ultimate power by declaring their constitutional amendments completely beyond judicial scrutiny. No review allowed. People actually call it the mini-constitution because it implemented the massive, sweeping recommendations of the Swaran Singh Committee. I mean, sure, it added socialist, secular, and integrity to the preamble, but it also aggressively targeted the judiciary. It severely slashed the power of judicial review and the writ jurisdiction of the courts. It even forced the president to be strictly bound by cabinet advice and gave directive principles precedence over certain fundamental rights. It was a highly calculated legislative strike designed to make Parliament absolutely supreme. So, Section 5, the Basic Structure Doctrine. How on earth does the Supreme Court defend the Constitution when Parliament is explicitly trying to make itself immune to any kind of review? This comparison right here brilliantly illustrates our core conflict. You've got the absolute sweeping rule of Parliament's amending power under Article 368 going head-to-head with the ultimate grand exception created by the judiciary, the Basic Structure Doctrine. The judiciary basically said, okay, yes, Parliament, you do have the broad legislative engine to amend the Constitution, but, and it's a massive but, you do not have the power to destroy its core identity. The idea is that the Constitution isn't just a basic list of rules. It has a soul. It has a fundamental framework that simply cannot be dismantled, no matter how huge a majority Parliament might happen to command. Now, you are absolutely going to want to memorize this list for your exams. These are the non-amendable features, the foundational pillars that make up the basic structure. They act as an impenetrable shield against parliamentary overreach. So according to the Supreme Court, Parliament cannot use Article 368 to mess with the supremacy or rigidity of the Constitution. They can't touch the federal system, the separation of powers, or the independence of the judiciary. And there is no way they can abolish free and fair elections or the secular nature of the republic. If Parliament tries to pass an amendment that damages any of these specific pillars, the Supreme Court has the absolute authority to step in and strike it down. The ultimate defining moment that cemented this doctrine was the case of Ananda Bharti case in 1973. Parliament had been continually trying to block judicial oversight, but the Supreme Court pushed back hard. They prioritized constitutional supremacy over parliamentary majorities by declaring that judicial review itself is a basic feature of the Constitution. You just can't take it away. By fiercely protecting their own right to review legislation, the judiciary basically locked themselves in as the ultimate gatekeepers of the republic's integrity. So, as we wrap up this wild constitutional history, I really want to leave you with this final thought. Based on the basic structure doctrine, who really holds the ultimate trump card in Indian democracy today? Is it the elected parliament, the ones who actively draft and reshape the laws to reflect the will of the people? Or is it the unelected judiciary, who carved out the power to determine the absolute, unalterable boundaries of those laws? It's a brilliantly complex balance of power, and truly understanding it is the absolute key to mastering